Well, good afternoon. Welcome to this session of the Justice Committee. Welcome to the Attorney General. Very grateful for you to come and give evidence to us, and good to see you. Before we start, just the usual declarations of interest. I'm a non-practising barrister, formerly consultant to a law firm.
I am a non-practising solicitor.
I'm a non-practising barrister.
And prior to my election, I was a magistrate, member of the Sentencing Council and non-executive director of HMPPS.
That's dealt with that. Well, Attorney, you came and gave evidence to us a while ago now, not long after your appointment, and I'll start with the same perhaps issues that we were talking about then, and that's just the nature of the office, which, as you explained to us last time, is unique in the sense that you take a separate oath as the attorney, which goes above and beyond that of the situation of other cabinet ministers, but is different again from that of the Lord Chancellor, say. So you're in a different position. You attend cabinet, though are not theoretically a member of the cabinet, but I think you attend all the cabinet meetings. Is that right?
Correct, yes.
And you sit on a number of cabinet committees.
Yes, I do.
And the solicitor, when deputising for you, does the solicitor attend any of the cabinet committees on your behalf, or?
Not cabinet meetings.
Not the full meeting, cabinet.
No,
but,
not cabinet meetings chaired by the Prime Minister. There are a series of subcommittees, and on occasions the solicitor will attend in my stead.
Yeah, much as with any junior minister. And so, yeah, no, that's understood. And we discussed about, you know, the attorney sitting at the sort of the junction of law and politics. Remember last time. And you said ultimately that you swore the oath that that the rule of law had to come first. That was your
correct. Yes.
That was your evidence to us. And I was just wondering, looking at the way where we stand now with that intersection, reflecting, have you developed your thinking at all as to what you see as the constitutional boundaries that constrain you in your work as Attorney General?
I think that's a great question because it's a unique role, and of course, as you all know, it's an ancient role. And I think the tension between the legal, the political and the constitutional has been present for as long as this role has existed, actually. And I think different occupants of the role have approached it in different ways over the years. Our tagline at the AGO is making law and politics work together, and that's how I do see it. I think I am at the interplay of law and politics. There are very clear areas where I'm acting as the guardian of the public interest. I'm really considering matters wholly from the legal perspective, as many of you around this committee will be familiar with, looking at the facts of an unduly lenient sentence referral, looking at the legal framework, merging the two and reaching an analysis based on the law, and switching off that political antenna that we are all possessed with. There are other occasions where I do bring the political side to the role more to the fore, and that is when I'm answering for the CPS at the dispatch box, for example. I'm acutely aware of the strategic objectives of the organisation that I superintend. I'm very much aware of the political objectives that the government has when it comes to increasing the convictions of RASO. But I was reading recently the seminal work on the role of the Attorney General by John Edwards, and he chronicles this debate over time, and there have been really different schools of thought. There's been one philosophy whereby previous attorneys have said there should be an independent aloofness of the attorney, and they shouldn't muddy themselves with the grubby world of politics, and they should really apply a wholly legalistic approach to their work. There have been other occupants in this role who've suggested that actually no, it's vital for the attorney to be intimately aware and involved with their ministerial colleagues' objectives politically, so that as the lawyer to the client, they are well placed to provide the advice on what is lawful and proper to assist the client, their ministerial colleagues, in achieving their policy objectives.
When you and I were in practice as lawyers, would we have expected, having given the legal advice, then let's say we're revising a company in relation to some matter, would we then expect to be involved in the board decision of the company? Or will we actually give our advice and step away, actually, and so it's for the board now to consider my having given my advice?
That's an interesting question. Well, I mean, you've got loads of different models. I mean, you will have general counsel, who will have a senior position in an organisation, but also be part of that organisation. You will also have instances where you go out for an independent opinion in the traditional model of going out to counsel. So, I mean, the way I see it is that I'm a member of the cabinet. I subscribe to collective responsibility. Yes. I am an elected politician. For me, the political thread that runs through this role is vitally important. The alternative, of course, is that the attorney would be an unelected, apolitical official. Yeah. And we already have many of those working for the government. I think there's a virtue to someone who is politically there.
Okay. Would you say you're a more political attorney than some of your predecessors?
I will let others comment on that. But I actually, I think I may have said this at the last appearance. The attorney's role reminds me so much of my time at the bar. It feels so much, I feel like I'm a barrister with a very heavy paper practice, less time in court, obviously, but it feels very, very much like being in chambers and considering papers and providing advice.
Now, you made a fair point about, in some respects, you're acting as a departmental minister with the superintendents. In other respects, you're the government's legal advisor. And when you're acting in that legal capacity, which you distinguished for us, of course, you have a legal secretariat to assist you with the legal advice you do, and of course you have access to Treasury Counsel as well. You're the first Attorney General ever to have a special advisor. That's bad. Well, what made you think that was useful to an attorney?
Well, I think there are huge advantages, actually, to the role of the special advisor, and you're right. I think I am the first Attorney General Special Advisor. And I think the virtue of having a political advisor is someone who can assist with the more political angles of the work. I can't go into the subject matters that I advise on, but some of them have huge political implications. I'm involved in some of the big issues that the government is grappling with, and they have very heavy, they are inherently political, and I think having an advisor who can bring that political dimension is very, very helpful.
And do they stand aside from any question that arises in terms of your legal advice to the government?
Yes, they do. They don't hold the pen when it comes to, composing the legal analysis and conclusions. But they do provide very useful advice on the political context.
Okay, that's helpful. In October, you made a speech, I think it was to the Public Law Project. And you talked about judicial restraint in pushing, perhaps, a concern, perhaps, that the courts in some areas might enter into the political arena. So it seemed to be an alarm bell that you were raising. What particularly prompted that?
I was honoured to be invited to give a speech at the Public Law Project conference on judicial review and trends in judicial review. And I emphasised the centrality of an independent, apolitical judiciary to our separation of powers and the way in which our country is a beacon of upholding the rule of law. And I was very keen to express a good faith jurisprudential disagreement with the Supreme Court. And the way I see it, there has been a trend which has emerged over several years, whereby, to my mind, the constitutional orthodoxy has been disturbed, and that the court has expanded its remit into more political realms, and that can have, to my mind, that will have profound ramifications for our judiciary. So I think that I'm very concerned about, if that trend continues unabated, there could be a risk to the legitimacy and the reputation of our judiciary, which is inextricably linked to its political neutrality, and which in turn could weaken the rule of law. So I think that essentially what I was doing was the position that the government adopted, say, in the Miller cases. I was extending that discussion and reiterating the government's position, which we adopted in that litigation and amongst other cases.
Do you think that potentially cuts across the position of the law officer, as opposed to another government minister saying it? Just wondered.
I think that's a fair question, but I don't think it does cut across. I think it is perfectly proper for a law officer to expand upon and discuss a position that the government has held in litigation, even after the conclusion of a case. And whilst we didn't win those cases, there's no secret that we disagree with the outcome. And I think engaging and enabling a discussion on the jurisprudence, on the rationale, and on the implications is only healthy. I was also very interested to read the policy exchange note, which was published quite recently with a foreword by our esteemed colleague, Sir Robert Buckland, QC, former Lord Chancellor and SG, about this very point, asking this very question, was it outside my remit to engage in this? And I was very encouraged with its conclusions, that which were, no, it's entirely proper and actually useful.
Excellent. Ms. Farris.
Thank you. Thank you, Attorney General. I'd like to pick up actually on some of those remarks. In your speech, you identified about half a dozen cases which you said had strained the principle of parliamentary sovereignty and introduced uncertainty into the constitutional balance between Parliament, the government and the courts. I think it's right to say that all of those cases went against the government, but in the previous government, the Blair government, the Brown governments, there were some very, very significant Supreme Court decisions against them: Guantanamo Bay, control orders, asset freezing. I would imagine all very unwelcome at the time they were handed down. Given that the Supreme Court, therefore, does, from time to time, interfere in cases of, ultimate public importance where the government is involved, why do you think the examples that you chose are different for the kinds of decisions that they were reaching a decade or so ago, which had just as serious ramifications, actually?
Yes, because I don't think that... I think what we have seen in the selection of cases that I highlighted, and this has been very eminent and reasonable experts have disagreed on this. It's a legitimate debate, and I'm glad you're raising it, and it's one that I'm very interested in. I think that the line of cases that I referred to, Adams, the Miller cases, Evans and Unison, Privacy International, to name a few, as you say, I believe has strained the principle of parliamentary sovereignty. And I think there's been much more comment, actually, from other experts to this effect. Some of these submissions to the IRAL, the Independent Review on Administrative Law, were very much emphasising this point. I refer you to the submission of Sir Stephen Laws, Professor Richard Eakins, a paper by Professor Varoas recently, which really talks about the mission creep of our courts, that over time judicial review has moved beyond a supervisory jurisdiction and actually extended into a conception of review whereby courts are exercising a primary and a determinative judgment over the justifiability of government action. It's moved beyond a supervisory jurisdiction, and that's putting its legitimacy into doubt. I'm quoting a little bit there from Professor Varoas' submission there.
How do you say, for example, the Unison case strained the principle of parliamentary sovereignty?
Well, when it comes to...
Parliament hadn't had any say on that issue. It was about tribunal fees, and it was the fees order was a statutory instrument introduced by Chris Grayling. Parliament didn't vote on it at all. So I don't understand how it minimised parliamentary sovereignty when Parliament hadn't been asked the question.
Yeah, well, I think, again, all fair questions. I think in some of these cases, there are really clear instances where the boundary has been transgressed. And if I can take them, in Miller 2, the court there held that a decision to prorogue Parliament would be unlawful if the prorogation had the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its constitutional functions as a legislature. And to my mind, that I believe the reasoning there was unusual, and that was an unprecedented decision when it came to the justiciability of what has formerly been and traditionally been considered as a prerogative power. In the Privacy International case, the principle of parliamentary sovereignty as traditionally and conventionally understood is that it's not for the courts to question primary legislation properly enacted by Parliament, in that case an ouster clause, or to interfere more broadly in parliamentary proceedings. But in that case, the courts decided to do that. In the Adams case, that's an example where the court, to my mind, turned upside down the principle of Cartona, whereby ministers have traditionally been able to delegate decision-making. And the decision in that case by the Supreme Court, to my mind, introduced significant uncertainty into a matter that had been previously a settled question.
Can I just go? Ms. Farris was asking about unison. And unison, as she points out, was an executive act. Are you saying that Parliament, the Supreme Court, should not review executive actions?
No, in that case, I did find, in my mind, that there was an extension, really, of where the courts should be supervising the acts of government, and I think they went beyond the mere analysis, which is traditional, assessing whether the act of the decision there was lawful and whether the process adopted was the right one. I think it went and strayed into a more policy kind of assessment, and it looked more in terms behind the decision rather than limiting itself to a more supervisory jurisdiction.
Wasn't Unison decided on strict judicial review principles?
As I said, it's my view that in that case the court did stray beyond the proper boundaries of where judicial review should lie. As I said, it's very important, this is why this is a really important debate that we have, that the boundaries of judicial review are properly drawn, and that's why we're introducing this new bill to try and ensure that boundary is properly honoured by the courts, and to ensure that there is a greater legitimacy to these decisions. I think that if we do see if this trend does continue, and we see as Lord Sumption would put it, the courts, the empire of law, assuming greater and greater territory from the legitimately elected lawmakers, i.e. Parliament and the legislature, I think that will have profound ramifications, really, for our separation of powers.
Ms. Farris?
Just my final question. We did a committee visit. We did a committee visit to the Supreme Court last week, and Lord Reid did address the issue of parliamentary sovereignty. And I suppose I'm just going to ask you to comment really on what he said. He talked about Miller 2, and he said that the case in the minds of the Supreme Court justices was about upholding the principle of parliamentary sovereignty. And I revisited the case actually before this session. Paragraph 41 of the judgment, the Supreme Court said, 2 fundamental principles of our Constitution are relevant to the present case. The first and most important is the principle of parliamentary sovereignty. And then in the following paragraph they said, an unlimited power of prorogation would be incompatible with the legal principle of parliamentary sovereignty. In other words, it would prevent Parliament from sitting and voting. Do you disagree with that analysis? And if so, why?
Well, my view of Miller 2 is that the court did intervene in territory which has traditionally been that for the executive and non-justiciable as a prerogative power. And to my mind, the reasoning and the logic that got the court there was, as I say, unusual. I was interested in Lord Reid's dissenting judgment in Miller 1. He emphasised there the risks of proceeding along this track. Paragraph 24, he said, for a court to proceed on the basis that if a prerogative power is capable of being exercised arbitrarily or perversely, it must necessarily be subject to judicial control, is to base legal doctrine on an assumption which is foreign to our constitutional traditions. It's important for courts to understand that the legislation of political issues is not always constitutionally appropriate and may be fraught with risk, not least for the judiciary. I concur with that warning that he issued in that decision, and I think that there will obviously always be issues with which people disagree vehemently, and there has been I just worry about the trend that we have seen of people who have campaigned energetically outside the courts, losing those campaigns and then pursuing those campaigns through our legal process. I don't think that's what our courts are designed for. The Lord Chief Justice has noted that, and it is, and again, Lord Reid, in the recent case of SC, he was more forceful in his comment here. He said, challenges to legislation on the ground of discrimination have become increasingly common in the United Kingdom. They are usually brought by campaigning organisations which lobbied unsuccessfully against the measure when it was being considered in Parliament, and then act as solicitors for persons affected by the legislation or otherwise support legal challenges brought in their names as a means of continuing their campaign. That's the issue I have. I agree with Lord Reid on that, and his warnings are very wise.
Okay, Ms. Abbott.
Thank you very much, Chair. I wanted to ask you a few more questions about the relationship between politics and the law. Obviously, you're a Conservative Member of Parliament, and I'm sure you're very assiduous in working for and speaking up for your constituents. But in the end, what is more important to you, your role as a Tory politician or your role in defending and standing up for our legal system?
Well, as Attorney General, I can't say that I think that both roles are can coexist and are both of equal importance to me, and they are both present in my role. For example, now as I'm sitting here, I cannot forget the fact that I am a Conservative politician, and I owe my position in Parliament to the good people of my constituency who chose to put me here. At the same time, I have a very specific and clear duties as the law officer, and I think what you're getting at, if I may, and I think the way I would answer the issue that you're raising is, as a lawyer in private practice, you're very used to you become. It becomes ingrained in you to turn off your personal perceptions, your biases, your instinctive reactions to your client or to a particular factual scenario that you're seeing. And it's the professional's duty to provide a standard of service which is not influenced by your personal or your political. And that's what I really call to mind when I'm exercising my legal role and my legal duties as AG.
Interesting how you describe your role. I've been a Member of Parliament for 34 years, and most Attorney Generals, both Labour and Conservative, see themselves as standing aside from party politics and actually, obviously, offering legal advice, but actually standing up and supporting the legal system as a whole. But clearly, you're not occupying the same position as previous Attorney Generals, and that you appreciate that is something of a surprise, certainly to people in the legal profession.
Really interesting that you raise that, because as I say, this is not a new question, and it's been around as long as the role of AG has been around. And there have been really good examples of different attorneys taking different approaches. Lord Hartley Shawcross, attorney in the 1945 Attlee administration, was very much of your view. The attorney should take a dispassionate approach and almost be akin to an official, apolitical. Peter Rawlinson, the AG in the Heath government, again, he really advocated for a non-elected, non-political public servant as AG. Contrast that, however, with previous Labour attorneys general, actually, who took a very different approach. Lord Elwyn Jones, former AG and Lord Chancellor, first attorney to Harold Wilson in 1964, he said this: "You may think by now that the AG is some sort of detached creature who has nothing to do with politics, but that would be highly disingenuous. In fact, the attorney, when he is acting in political matters, is a highly political animal, entitled to engage in contentious politics. I suppose the only thing one can say is that some attorneys are more contentious than others as politicians. But the basic requirement of our Constitution is that however much of a political animal he may be when he is dealing with political matters, he must not allow political considerations to affect his actions in those matters in which he has to act in an impartial or even a quasi-judicial way." So that's a very different approach, again, maintained by another Labour Attorney General, Sam Silkin, attorney for Wilson and Callaghan, took very much that similar approach. The attorney, to be effective in his or her role as law officer and legal advisor to the government ministers, really needs to be aware of their political objectives, the political stresses, the political strains, the temperaments, the characteristics of that Prime Minister, those ministers leading their policy objectives, so that that law officer can be in the best possible position to provide that advice on what is lawful and what is proper to enable those ministers to achieve their policy aims.
Well, I don't want to pursue this much further, but it's interesting that you quote Labour Attorney Generals, but I could quote two other Labour Attorney Generals that took a position much more in the classic understanding of the Attorney General's role. And so you will hear increasingly now barristers, judges, people in the criminal justice system who express concern about what they see under you as a politicisation of the Attorney General's role. Are you saying you would dismiss those concerns?
I'm not aware of those concerns, if I'm honest. So the way I see my performance in this role and how I do this job is that I've been able to, when it comes to the legalistic side of the role, considering the consents for prosecution, assessing whether a referral should be made to the Charity Commission, considering the referrals on unduly lenient sentencing, providing legal advice, that I have been able to maintain quite a clear-eyed legal perspective. I'm a trained lawyer. I've practiced for many years. I'm able to do that. Equally, as I say, I am a politician, I am elected, I'm subject to collective responsibility, and I feel very comfortable in discharging those duties as a politician to my political team.
Well, then let's move on to what you were quoted saying about the Colston 4 case. I wouldn't ask you to expand on your opinions because it could yet prove to be sub judice. But there was the sense in which you were quoted as saying that you were expressing concern about the jury's decision and even expressing concern about the advice that the judge gave at the beginning of this case. And as I say, I mean, you may not have heard this, but some people were surprised that an Attorney General would want to query a decision of a jury. It's almost as if you only support jury findings when they come out in a way that you would like.
Not true. I would disagree. I don't think anything I've said has sought to undermine trial by jury. In fact, I make it very clear that it's an important foundation of our legal system, and I very much respect the jury system. It's a guardian of liberty. However, I do have a statutory power. It's Section 36 of the Criminal Law Act 1972, where I can, if I seek to do so, refer a decision, a point of law which has arisen in a case to the Court of Appeal to ask for their opinion on it. And my mere consideration of this matter, I don't think suggests anything unduly political or improper. Considering this matter, which is what I expressed and which is what I'm doing, is entirely within my remit and indeed my statutory power.
And so you don't accept that your remarks, coming in on the back of a sort of torrent of critical statements by other Conservative MPs, you don't accept that your remarks were in any way political?
No, I don't.
And although, because I read what you said, and you started off by saying, I entirely support the judicial system, the system of trial by jury, but then you said, I may find myself, obviously you've got to wait for the CPS, but I may find myself throwing this to the Court of Appeal. And in the context, and you're a politician, you understand that context is very important. In the context, it seemed as if you were more seeking to echo the opinions of your Conservative colleagues than, in practice, defending trial by jury.
That's not my intention. My intention is to legitimately identify points of law that merit further consideration by senior judges, as our system allows. A referral was made in 2020, most recently, and that was a very helpful referral that we made, and the Court of Appeal agreed with the referral on the law of sexual assault. We've exercised this power on many occasions in the past. It won't change the verdict in that case, but if I do conclude that there is a question of law that merits further inquiry by senior judges, I will refer it, and I won't hesitate to do so. Equally, if I find on the law there isn't such a question, I won't refer it. It is a statutory power. It's a useful power. I'm not alone in identifying questions. Many reasonable people, again, have disagreed. There's been a lot of comment by lawyers on both sides of the debate who have said there is some kind of question here. The Lord Chief Justice himself, in a judgment recently, highlighted the potential for questioning the area of law. So I think that there's quite a crowded field in terms of people who are looking at the law here and considering it.
Finally, Chair, you've spoken a little about parliamentary sovereignty and how you're worried that the power of judicial review might undermine parliamentary sovereignty. And I understand what you're saying, but I also understand, because I have been an MP for 34 years, that on occasion, this would be shocking to you, but on occasion, Parliament passes legislation which is both incredibly short-term in what Parliament is doing, which is not necessarily based on the facts, which is not fair, which is not right. And surely, sort of, men and women, British voters, ought to be able to look to the courts in cases like this to stand up for what is fair and what is just. You cannot assume, and I hope you're not assuming, that everything Parliament passes on a given day is always right and is always fair, is always even based on the law in reality.
Well, first of all, judicial review is an important mechanism. It's a vital check and balance in the system because whether it's government bodies, whether it's local councils, whether it's anyone with any form or degree of executive power, that needs to be held to account in some form, and judicial review provides that mechanism. So it is a vital mechanism. However, I think parliamentary supremacy is the foundational cornerstone to our democracy. It's the mechanism through which the British people are empowered. They send all of us here through a legitimate mandate, and they can kick us out if they so wish. And we express their views as faithfully as we can through the work of the legislature and through acts of Parliament. Government initiates legislation, and if Parliament doesn't like it, Parliament can reject it or amend it. But the final product has gone through a very rigorous process. It is reflective.
You're obviously not sat in Parliament for many years if you think it's always...
We might be in danger of getting into comment rather than...
Sorry, Chair, sorry.
I think it was Abbott.
I think that the hours of debate that we spend in both chambers, the level of scrutiny in committee, the opportunity for amendments and votes, I think that's a pretty rigorous process, and it's the best we've got in terms of reflecting a democratic mandate. And I think given the survival of our parliamentary democracy, it's pretty good, and the fact that it's emulated around the world, it's not working too badly. But I think we do have to honour the doctrine of parliamentary supremacy, and I think actually there's a real opportunity for parliamentarians to be more empowered in how the legislature is marshalled for our constituents. That's what democracy to me is all about.
Thank you, Chair.
Thank you, Chair. Dr. Mullan.
Just building on the questioning that's arisen around the 36 power, you mentioned it's been used on a number of occasions. If you don't know the figures off the top of your head, could you supply us with the exact numbers perhaps over the last 5 to 10 years, just so we have some sense of proportion? And would you agree with me, framing the question in another way? We've talked today a lot about the importance of the separation of your political functions and legal functions. If your legal function as such felt there was a point of law that needed to be contested, and you allowed political considerations about how it might look, what the debate was, to stop you from making a referral, would you agree that's in another direction just as concerning?
Yes, absolutely. I think it's absolutely vital that the legal considerations are left to take their course in as sterile a way as possible, without influence of politics, either way. Yeah.
And my colleague has mentioned the visit to the Supreme Court and some of the discussion we had, and I think I would also be fair in reflecting that we talked about this issue of MPs commenting on judicial proceedings. Actually, I think I'm fair in saying that a number of the justices said it was perfectly legitimate for MPs to pass comment on cases, on rulings, etc. That's part of the checks and balances too, that actually isn't an idea of the judiciary existing in isolation from society, politicians and wider public opinion. I mean, would you agree that is an important role for politicians?
Yeah, I think it's difficult for an attorney to comment on ongoing legal proceedings, but as a legislator, an MP, I think it's completely proper for MPs to have an opinion and voice it.
And finally, on that, being a bit more specific, I think whilst party politics is obviously not necessarily in play when it comes to decisions of the court, when it comes to things like weighing up competing rights, actually those are inherently political decisions with a small p about what priority you might give to the right to protest over any other rights. Those are, by their very nature, political. Even if they, in case law, are built upon decisions, at their root, they are political with a small p.
Yes, I would definitely agree with that. And I actually think our constituents, constituents of MPs who are not members of the government, but would find it quite odd if their elected representatives were silent on contentious issues which are very political by nature. And I think they would be wondering what their politician was doing if they weren't having a view, at least, if not expressing it. And I have got just a list of since 2000, there have been 20 referrals under Section 36.
Okay, thank you. Thanks very much.
Thank you very much. Ms. Eagle.
Thank you, Chair. I want to move on to asking a little bit about your priorities and the spending review. You've got through spending review 21 an extra £183 million for agencies which you have a superintendence over, including the Serious Fraud Office, and it was said in the Treasury documentation to be 2.2% a year in terms of an increase. How much of that will go to the Serious Fraud Office?
Just get that section.
The allocations used to be seared into my mind when I was a departmental minister. You've obviously, maybe you haven't quite got there yet on the decision on the allocations.
Well, when it comes to the spending review, there were uplifts at the 2021 spending review, and the SFO has a core resource budget of around £55 million per year over the next 3 years. And its resource funding for 2022-23 is 55.
That doesn't sound like an increase at all.
No, sorry. We've got when it comes to resource and capital funding, it's a proportion from 22-23 of 3.1 million for the capital budget and 55 million on the resource budget.
So, am I right from what you said there that there isn't an increase in the resource budget planned?
Well,
the SFO?
This is supplemented by additional funding from the Treasury Reserve. So the Treasury Reserve funding enables the SFO to obtain additional money for cases where costs exceed more than 4% of its budget during the financial year.
So on a case-by-case basis, you might get some more money for the SFO if they're doing a big prosecution.
Yes.
But there has been a decline in prosecutions, hasn't there, of major frauds, money laundering, a decline of 35% since 2016. For example, there have been an average of 5 cases a year in the last 5 years. There were 4 last year, and this is down from 13 in 2016-17. So you don't really expect to call on that extra potential money from the Treasury by the sound of it. Presumably that's why it's not in the core allocation. Well, am I right, or am I being a bit cynical?
I wouldn't want to prejudge the work of the SFO. What we do know is that it's important to remember that the SFO is both an investigator as well as a prosecutor, and it can only ever progress to a prosecution when the available evidence is strong enough to support one. And bringing a weak case is simply not an option, or is it in the public interest? And therefore, there will be some investigations which close, either because the investigation hasn't shown that there is, there's a case to answer, or because there's insufficient evidence, and that's the same as any public investigative agency. I think the ambition of the SFO is very clear that that we want to ensure that cases, if they can be resolved by DPA, that's a good and efficient and cost-effective way of proceeding. But if it needs to go to trial, then that reflects really the facts of the case and the level of cooperation by a company. We need to focus on the best outcomes from an interest of justice point of view and the public interest.
Do you accept, that economic crime costs the UK hundreds of, billions of pounds? In fact, the National Crime Agency says money laundering costs the UK £100 billion, loss to fraud, £190 billion. These are enormous sums, and we all have constituents who are subjected to appalling fraud, sometimes their entire life savings, most of whom never have a cat's chance in hell of getting the money back or seeing any justice against the people who've perpetrated it. So there's a lot out there for the Serious Fraud Office and National Crime Agency, these national agencies, to do. That's right, isn't it?
I don't want to diminish the seriousness of economic crime and fraud. It is a very worrying concern. There is a lot of action and commitment going on by the government to try and deal with this. We've got the Economic Crime Plan, launched in 2019, which represents a step change in our response to economic crime. We want to work to ensure that the environment for economic crime within the private sector is disrupted. We want to ensure that we have measurable progress against our economic crime plan. There's investment, and we need to empower the agencies, and that's why the National Economic Crime Centre was established to coordinate activity to tackal economic crime.
Except that increasing the budget actually empowers the agencies to tackle some of this. At a national level, the agencies fighting this kind of crime get about £852 million, all of them in total, if you believe what the report published earlier this week called Spotlight on Corruption sets out. £852 million. And they say that the UK spends under 0.1% of government expenditure, whilst losing the equivalent of 14.5% of GDP. Now, given that you do have, you can generate money, as you've suggested, in settlements through deferred prosecution agreements, and indeed the SFO have done so very, very successfully, 1.6 billion in settlements in the last 5 years, and other hundreds of £1 million in fines and penalties. Why on earth, given that there's £100 billion lost of money laundering going on and £190 billion of fraud, why on earth don't you empower these organisations, national organisations, including the SFO, to tackle this properly on a much bigger scale and make it absolutely clear then that the UK is a good place to do business, rather than some kind of wild west where economic crime is shooting up to huge levels and actually deters people from doing business in this country? Why don't you do more?
Well, I think our settlement in the spending review does represent a serious commitment by the government to ensure that the SFO has the right resources and the right tools to work effectively against the fraudsters and the criminals. And I think it takes on some of the most complex and difficult cases. It's achieved certain successes. I'm grateful for your acknowledgement of them. I don't think they get enough acknowledgement, the successes of the SFO, actually. And it continues to deliver good operational results, taking into account the judicial resolutions such as DPAs. Its successful judicial outcomes rate is 84% by case and 56% by defendant over the past 4 financial years. Over £7.3 million in financial orders were obtained by SFO's proceeds of crime team, and over £6.9 million last year was recovered. It's making good use of its legislative tools available to it, whether it's within those contained in the Bribery Act, in the 2013 Crime and Courts Act, or the Criminal Finances Act. It's agreed 12 DPAs since 2014. Total value, as you say, £1.7 billion. So I think that it has good tools. Does it need more resources? Yes, the inspectorate is very clear. It needs better digitalisation.
You just seem to have told me that there are only new resources on a case-by-case basis for prosecutions. That's what you said at the beginning of when I first raised this question with you. So that doesn't seem to me like you're giving more resources to expand the capacity to deal with some of this huge level of fraud. Loss to fraud, £190 billion, says the National Crime Agency. Money laundering, £100 billion. I mean, what you've described, the 1.6 billion sounds minuscule in comparison to those levels of fraud, and yet you seem to be saying to me that your settlement has, on a case-by-case per prosecution, capacity to give a bit more money to succeed with a particular prosecution. That seems to me like doing the absolute minimum, Minister.
No, I disagree. I think that we, as I say, we've seen some some successes. I don't need to go over those but they represent the value for money that the SFO provides, and the settlement that we've secured at the spending review will go forward to boosting its resources. There's a serious issue with the SFO when it comes to its digital capability. That's a well-known challenge for the SFO. We need to make it nimble. We need to make it a competitive employer so that it attracts the best lawyers out there. We need to bolster its army of people who can deal with the very complex disclosure challenges that serious fraud poses these days, who can ensure that there's sufficient grip and case progression in its caseload. The SFO has a large number of difficult and complex cases currently on its books. It's working through those at pace, but this spending review settlement will go towards ensuring that it has much more money diverted to where it's needed.
Right, okay. What more money? Because I thought you'd said to me that there was a special fund that the Treasury would allow them to draw upon in respect of a particular prosecution, not lots more money to sort out their problems with digital issues that they might have in the office. I mean, it didn't sound to me like you were saying there was more investment in the SFO itself. You were saying there was the capacity for them to tap more money for a particular complex prosecution, but there've only been 4 in the last year, and that's down from 13 in 2016-17. That's not even going in the right direction. I realise there are issues with investigating such things. It takes time, but I realise that. But the numbers overall are going down, yet the levels of fraud, it's £190 billion going up, money laundering, £100 billion going up. There's lots for them to do.
Yes, and it's not just the SFO, it's also the CPS. So both prosecuting authorities have a role to play when it comes to economic crime. Both have specialist lawyers who are working on this, and both need the resources to deal with the challenges. And they do have, so thanks to the spending review, thanks to this government's investment, a chance of ensuring that they have the right capabilities to deal with these challenges.
Okay.
Oh, well, I'm not sure I'm getting anywhere, but I've one more question.
Yeah, we've got a fair bit to get through yet. So it
is it right that the proposed economic crime bill has been postponed from being in the next Queen's speech, as has been reported? And if so, why?
Well, that's not. I have to confess, it's not. That's not my responsibility. That economic crime bill. I don't know whether that would be. Well, you have
superintendents over the SFO, which does deal with economic crime, but perhaps you could drop us a line.
I can find out, but I don't know the answer.
Okay.
Thank you.
Thanks. We're going to stick on the SFO and then the agencies. So, Mr. Maynard.
Indeed, back to the SFO, or as it's known in the City of London, the Serious Farce Office. Do you still have confidence in these at Sovsky?
Well, I know what you're alluding to. There have been some high-profile failures and case collapses recently, not least the Unaoil matter. I do still have confidence in the director. I think that, as I said, under her watch there have been some significant and high-profile wins which were not easily gained. And I think that we need to give credit where it's due. However, I accept there's a very serious issue when it comes to broader performance issues, but also as a direct consequence of the Unaoil case.
In the earlier answers, you mentioned disclosure issues regarding both the Unaoil case and the Serco case. I know that you called for a report, I think, back in December now. When would that report be being published?
I can't put a date on when it will be published, I'm afraid, but I am moving very swiftly with, I've obviously commissioned already an independent review. We're in the process of confirming the person who will be carrying out that review.
But you've not even started it yet, then?
It hasn't started. It hasn't started yet. It does take time to identify a person and confirm them and get them in post.
And forgive me for going back to the budget yet again of the SFO. You mentioned that you will be able to draw on special treasury reserves on a case-by-case basis. Did your discussions also include any potential liabilities the SFO might face as a consequence of ongoing proceedings against it. It might exceed its annual budget. Was that part of your discussion with the Chancellor?
Well, on a net basis, the SFO returns money to the Exchequer in terms of the £1.3 billion that it recoups from DPAs and legal decisions. So it is actually one of the very few departments that is sending money back to the taxpayer rather than actually taking it.
It can afford to be sued ad infinitum because there'll always be a pot of money that it can make things better with.
Well, we want the SFO to apply a very high standard of legal decision making when it comes to investigation and prosecutions, and we want those decisions to lead to successful convictions, and that will, the more successful convictions that they secure, the more financial remedies there will be coming back to the Exchequer.
Now, my last question: when did you last meet Ms. Osowski?
Very recently. Well, following the judgment of UNOIL, I convened an urgent meeting with Ms. Osowski, and I asked her for, I probed her on what her view was of what happened and why. So, immediately after the judgment.
Right, thank you.
It'll be convenient to stick with the agencies, if I may, and then come back to Ms. Hollern. So, Mr. Butler, because we're going to turn now to the Crown Prosecution Service, which is the other agency which you have responsibility for. Mr. Butler, and then Ms. Farris.
Well, thank you very much indeed. You have Attorney General as superintendent's role over the CPS, but of course it's the Director of Public Prosecutions that has the day-to-day managerial responsibility, and he in turn is responsible to you, it being he at the moment. I just wonder if you could sum up what you see as your role in that superintendent's function and what influence that then has on the CPS.
Yes. Well, superintendence is a statutory term used to describe my role in relation to both the SFO and the CPS, and more commonly across government it's referred to as sponsorship. We have a framework agreement between the prosecuting authorities and the law officers that was updated in December 2020, and that goes into some detail about what this relationship should involve at a practical level. What it looks like is the law officers supporting and holding the DPP to account for the running of the CPS and the discharge of its functions. Of course, that means that we do not intervene in any operational or casework decisions, and we are except in exceptional circumstances, for example, national security matters. But it is a really important feature of superintendents that there is operational independence afforded to the CPS.
Would your superintendent's role go as far as exercising any influence about where, for example, the CPS should prioritise its resources or its functions, or is that operational?
In terms of allocation of resources, a bid to the Treasury is made by the CPS in the first instance, and I will provide guidance and challenge to the CPS on the preparation of their bid, and we do work quite closely, our two departmental teams, on the preparation of that bid. So I challenge the CPS on their proposals of funding allocations, and I say, well, we've got a problem here. Surely you should be thinking more about diverting resources there. The final decision, however, is with the CPS. I can't impose a view on how I think their money should be spent. They will make that final decision. It affects their operational capability, and then I will advocate for them with the Treasury on the basis of a finalised bid.
So you wouldn't say to them, I think that you should prioritise more effort on rape, or I think you should focus to a greater extent on economic crime, or I think that you need to put an increased amount of staffing on disclosure. That would be a step too far.
I can say that, I can definitely say that to them. That's a strategic issue. It's government funding. We're in that exercise together. It's perfectly within it's very much part and parcel of my role to say to them, I think you should be thinking about diverting resources and to this area or that area. But the final decision will be the CPS's, and I can provide that challenge and that probing, but ultimately it will be their decision.
Can you give us any indication of where you've asked them to focus some effort and whether or not the directors agreed with you or not, and what happens if there's a disagreement?
Well, the focus has definitely been for a few years now on RASO, and there's not a meeting, I don't think, that goes by when we don't talk about RASO and resources and allocation and planning. And that's definitely been, I haven't actually had to push the CPS too hard. I think they've been, to their credit, very forthcoming and forward-leaning with really gripping the issue of RASO, wanting to divert and ask for and divert more resources towards their specialist prosecutors, towards their greater resources generally, towards their prioritisation, and they've really wanted to deal with that issue.
I know my colleague's going to ask you a couple of specifics on RASO. Are there any other areas where you've asked the CPS to focus or to put more or less of their effort?
Well, there is also the inevitable and ever-present challenge of dealing with the backlog. So that is a priority for the CPS and for myself, that issue. And you will always have, the CPS will always have, the director will have the challenge of, if we're going to divert resources from one task, we're going to be maybe depleted in another. That's a decision that we're always grappling with as politicians, as ministers. So I think that, yes, there are many, many issues that I raise with the CPS.
You mentioned that you advocate for the CPS as well as holding it to account. What is your relationship with the Chief Inspector of the CPS?
So the Chief Inspector sits in a different organisation in the Inspectorate. He's relatively new, a new appointment. And I'm very, very, I really welcome and encourage his work and his reports. I read them very carefully. The Inspector, my relationship with the Inspector is that we will have a regular meeting. I can, suggest or request particular subjects for inspection. He may come back and say, yes, that's a great idea. No, we can't do that because we haven't got resources. It's a dialogue, and I would say, work together depending on current priorities and the current context. But they update me intermittently on their work, on their findings. We always have a meeting after a report has come out so that I can probe them a little bit more, ask a few more questions. But their work of inspection and recommendation is wholly down to them.
Are there any particular areas at the moment where you would like the inspector to carry out inspections?
There are always more questions that I would like them to answer than they're able to. Their focus is on RASO performance, and their area inspections are coming through now. We've had, I think, 4 at the end of last year. We've got a couple more coming later this year. They're really comprehensive. They're really giving a kind of on-the-ground picture of how the police and prosecutors are working in dealing with general crime, but also RASO, on disclosure, on pre-charge review, post-charge review, preparation for PTPH. Is really, you get a really granular idea of how different areas are performing. So I think their agenda of work is spot on really at the moment.
Do you largely push the CPS to accept the recommendations of the inspectorate and ensure that they are delivered against?
I don't have to. The CPS, as long as I've been in this role, have not hesitated to accept all the recommendations made by the inspectorate so far.
Thank you.
Thank you very much. Ms. Farris.
Thank you. I've got 2 more questions on RASO. Prior to the publication of the rape review, there was the action that was brought by the Centre for Women's Justice against the Director of Public Prosecutions, where I know they were unsuccessful, but certainly an impression was allowed to linger that the CPS were part of the problem in the low prosecution rate for rapes. At the same time, I think you know, Attorney General, that I went to a meeting with Max Hill some months ago, and he talked about guidance that had been published by his office that went to all kind of the CPS around the country after the Domestic Abuse Act became law. And that was about things, the new provisions around things like the rough sex defence. Even though it had been a common law principle before, I think it can reasonably be inferred he wasn't confident that that had been faithfully applied by prosecutors. So can I just ask you, really, in the context of those two things, when you became Attorney General prior to the rape review, had you formed the impression that there were failings in the CPS with rape prosecutions? And are you satisfied now that the changes, or first of all, that there are changes that are happening? And if so, are you satisfied that they're going to make a difference?
I think this is a very complex issue, and it's not easy to say, well, that's the cause, the CPS is to blame, the police are bad, the courts are... It's not as simple as that. It is so multidimensional. And I think, there's a general understanding, and it's definitely my view, that the whole system needs to improve, right from the moment someone plucks up the courage and walks through the doors of a police station to make a complaint to hopefully, where that defendant is sentenced. And that whole life cycle needs to improve. And that's what is reflected in the end-to-end rape review. That's a large piece of work which is trying to chronicle the victim's experience, with a very close eye on the fairness to the defendant, of course, but trying to, it's a broad acceptance that the whole system needs to improve. And so for the CPS's part, yes, there's a definite need to improve the numbers of the numbers that are being charged, to put it simply. We're seeing some signs of improvement. I'm really encouraged by the willingness and the commitment from the CPS to deal with this issue, to grip it, to be open to suggestions, and to be very forward-leaning, as I say, in how it adopts different practices of working, how it publishes its data. Data is a massive factor in this whole thing. We've been working in the dark for many years. Only now are we beginning to see the actual numbers in an empirical format. So that's going to make a massive difference.
Speaking of numbers, one of the things that the policing minister has said is that he thinks that the effect of the compulsory publication, it's got a title, hasn't it? The criminal justice scorecards will make a difference to the way that different police areas will perform in the way that they handle and investigate rape claims. How is the CPS working with different forces to ensure that those improvements are made? Because ultimately it's the CPS who makes the prosecution decision, the charging decision.
Correct. The CPS makes a very important decision in that life cycle. However, the CPS can only consider cases that are referred to them by the police. Very important factor. And the scorecards have shown that there's a massive drop-off between the number of complaints made to the police and the number of cases that the police actually refer to the CPS for a charging decision, about 1 in 10. So the CPS is receiving 1 in 10 complaints. Latest scorecards and figures show that their charge rate on that admittedly small number is about 68-69%, and that's the highest charging rate in several quarters, actually, from a low of 47%. So again, encouraging sign. Can they do better? Yes, but a good, good first steps being made. And your question was about what is the CPS actually doing?
Yeah, well, does it have any part to play in getting...
Yeah, of course. Well, I think, notwithstanding those early signs of progress and those tentative green shoots, I think that what is hopefully going to make a difference. And again, it's really much based not just solely on the CPS, but on CPS and police collaboration. Are some of the working practices which are being pioneered in Operation Soteria and Bluestone in the Avon and Somerset region. And I think that that's really informed by academic expertise, specialists in the field, and what we are finding there is that by enabling earlier meaningful liaison between prosecutor and police officer, you may well save time. avoid duplication, pursue the reasonable lines of inquiry, adopt a much more pragmatic approach, be able to reach a decision sooner. And that can make a massive difference to the prospects of a complaint, actually, and could make the difference between a complaint receiving a charge and not receiving a charge. So that, I think, is something for us to watch closely, and I'm looking forward to confirmed results emerging very soon.
One of the areas, of course, where RASO has been engaged, but it runs right across the piece with the CPS, is disclosure. And we know that's a growing problem, as you pointed out earlier, with the amount of digital material which have to be considered by both police and the Crown Prosecution Service. You revised the disclosure guidelines in December 2020. Can you help us as to what impact those revisions have done and how its impact is being monitored by the CPS and yourself?
Yes, thank you. Disclosure goes hand in hand with RASO. Because of the quantity and the complexity of the evidential burden that both police officers and prosecutors are dealing with in 2021, 22, in more recent years. And that's been a real sea change, I think, and been an aggravating factor to their performance. And therefore, disclosure is incredibly important. What my guidelines sought to achieve was a sea change and a radical change in how operationally the police and the prosecutors were dealing with disclosure. Previously, disclosure has been an annoying afterthought, a technical, administrative nice to have that would often be remembered very late in the day, causing real disasters in the court process. Liam Allen is the high watermark, and what my guidelines have sought to achieve is to change that and to make disclosure much more of a running theme from day one. The thinking approach. It's very much focused on front-loading the work, so earlier disclosure, earlier engagement between defence and prosecutor. Let's put cards on the table sooner down the line, and if a defendant can get good legal advice on the basis of a fuller evidential picture, that may well save a lot of time and effort later down the line. So I think that there is a real need. We always have to bear in mind the fairness, and we need to ensure that there's also a focus on protecting victims. They don't want, too often victims have felt like they're the ones on trial, and they felt that there's been an excessive level of intrusion into their private lives, the confiscation of their phones. And that's why the rape review talks about, the 24-hour grab of the phone. But we really want more grip, more earlier engagement, and front-loading of the disclosure process.
And how are you measuring the effectiveness of the guidelines in achieving that? Is there a mechanism to do that?
Well, I committed to having an annual review of the disclosure guidelines, and we're fast approaching that point. Yes. And the review has started, and we have I've been receiving a lot of representations and feedback about how these disclosure guidelines, accompanied by DG6 at the CPS, have bedded in at an operational level, and it's been incredibly useful. And I want to do what works. I have no qualms in changing these guidelines if that's what professionals request. And what I'm encouraged by is that what we're hearing so far is that, on the whole, number one, that they're kind of in the ballpark area, they're kind of spot on, the guidelines. They're really welcome. The change in ethos, the change in focus, that's been welcomed by practitioners. Guidance on third-party material, number 2, could be improved to clarify and strengthen the standard for accessing that information. Number 3, we're hearing potentially a need for more clarification to be given to the defence as to how and when they should engage to narrow the issues in the case. And lastly, some of the feedback we've got focuses on a redaction. And I don't know if you heard this from the policing minister, but I'm hearing, my review is showing this, but I've also heard from professionals that the burdens of redaction are excessive and onerous and disproportionate, and we need to try and recalibrate that.
That's very helpful. Sir Christopher Bellamy gave evidence to us last week, and obviously he was dealing essentially with legal aid matters in his review, but you probably picked up yourself. He referred in his evidence to us about what the evidence he'd picked up, suggesting a drip-feed approach to disclosure. Does that ring a bell as far as you're concerned, and if so, what's being done to tackle that?
I've been really encouraged by Sir Christopher's report, because I think there's quite a lot of focus actually on the front loading of disclosure, and he talks specifically about how time and money and resources can be saved if there's a cards on the table approach earlier on in the process. And I think that that will demand more resources and therefore funding. And I think if I really welcome his findings and analysis on that.
Okay. You mentioned backlog. I'll go to Ms. Eagle on that, then Ms. Hollern.
Okay, yeah, just briefly on the court's backlog. I know it's not just your responsibility, as it were, but the backlog's going up at the moment. It's above 60,000. I think the target is. We're talking about the Crown Court backlog here.
Yeah.
The target is to get it down to 53,000. Spending all of the money that's allocated from the 21 spending review. The aim is to get it down to 53,000 by 2025, I think, speaking from memory, which isn't, it's still quite a large backlog. It will still be higher than before the pandemic. So I wonder whether or not you think that is possible, doable, but also do you think it's sufficiently ambitious?
Well, we're obviously in an unprecedented time because of the impact of COVID on the criminal justice system, and we need to ensure that our justice system continues to run. I'm very glad that we're one, in our jurisdiction we didn't close our courts during the pandemic, and we did manage to keep them functional. I think that was a real achievement. Funding is important to this aim of bearing down on this backlog in the Crown Courts, as you say. Notably, in the magistrates' courts, we're back to pre-pandemic levels, where essentially that's 80% of crime. So a large chunk of disposal of criminal matters is actually being progressed well. You're right to focus on the Crown Court backlog, of course. So when it comes to funding, the government is investing across the justice system. £80 million a year by 2025 has been allocated to the CPS, and partially that will help to tackle its backlog. So for the CPS's part, there is a backlog within the organisation, and that needs to be worked through. That will help overall with the backlog of the CJS.
Yes, but we've just been talking about serious sexual crime and waiting for years, either as a defendant or as a witness or as a victim, to get a trial on. Because of these backlogs, most of these are Crown Court trials, has severe impacts upon whether or not justice is done at the end of the day, and on the mental health and well-being of those involved, particularly on the victims. 53,000 backlog, still higher than pre-pandemic. After all the money's been spent in the spending review by 2025, doesn't sound particularly ambitious, does it?
Well, I think there's lots of angles to this. Of course, we need to eliminate the backlog. We need to get to a position where people are not waiting years for their matter to come on trial. I think this is going to be a gradual process. We need to do this carefully. Sir Christopher Bellamy's report talks about ways in which, by using funding smartly when it comes to legal aid funding, and, for example, making the process of disclosure more effective earlier in the process. That's a way to actually ease the backlog. Because if you're getting defendants, able to have better sight of their evidence sooner in the process, able to access a good solicitor, they may well put in a plea of guilty, and that may well ease that will be one less case. Now, if that requires systematic change, that needs more funding. That's why there are many pieces to this puzzle, and the funding on legal aid is one piece. But as I say, what the CPS does is another piece, and that's why the inspectorate, in fact, looked at the CPS's response to COVID. It judged it to be a very good response, very nimble and very flexible. It implemented a series of changes with cross-system partners to respond to the pandemic. For example, the interim charging protocol, designed to be clear about its prioritisation. And CPS areas have been working very closely with HMCTS to ensure that cases with vulnerable victims, including domestic abuse and rape and serious sexual assault cases, are prioritised in court.
Then I'll finish on this, Chair, as we're in a rush. But the point is that even after all the money is spent and all the things you're talking about is done, the backlog is planned to be 53,000 by March 2025, which isn't that far below where it is now, although it's going up at the moment. And the reality is that many victims of crime, many defendants, are going to have to wait years to get those trials heard, and whether or not that is proper delivery of justice, I think, is a moot point. Chair, I'll leave it there.
Well, I think it's more a comment than a question, perhaps.
I think it turned out.
I think it turned out to be a comment, didn't it? So let's move straight on to Ms. Hollern, who's been waiting very patiently.
Thank you, Chair. In our report, COVID-19 and the criminal law, we concluded that there were important lessons for the government to learn about the creation of enforcement of criminal offences. What lessons have you learned from your time in office during the pandemic?
Well, I think COVID posed very unique challenges to the government. There was no template to follow in how to respond to COVID. And for my part, what lessons did I learn? Well, I was quite... I have been impressed by the responsiveness of government and government agencies, the CPS, relevant to my work, in kind of replying swiftly to the complexity of the challenge. So whether that is, from a law officer point of view, for me, the departmental lawyers and the departmental officials led by ministers designing, very, very wide-ranging and important legislation, such as the Coronavirus Act. That was a huge piece of work involving, significant amounts of effort at pace. Whether it was that aspect of thinking quickly in a crisis on how to legislate and allow the powers to be taken for the government so that the right the right measures could be put into place, or whether it was looking at it from a justice system point of view and how we working with this was an MOJ aspect of work, but how as I say, we didn't close our courts. We managed to find workarounds, and we of course many matters were paused, but the digitalisation of many areas of law to enable the continuation of the administration of justice, again, was a reflection of that nimbleness and agility.
Can you tell me what your role was in the creation of the COVID-19 criminal offences?
I personally actually did not have any role in the creation of offences. The Coronavirus Act laid out the legal position and what would constitute a breach of the law. Those were essentially policy decisions reached by other ministers. The law officers played a part, at the PBL level, so we do scrutinise legislation in its draft form, as you know, and we raise any legal issues if they arise at that point. But in terms of the policy formulation, that would have been a lead for another minister.
Well, that's interesting because, of course, last week the Prime Minister said that he was unaware he was breaking the law, and you just, if that was a policy decision, he would have understood that. However, have you at any stage been asked to give advice to the PM or the Cabinet of the implications should they be found to have broken the law?
Well, unfortunately, the Law Officers Convention precludes me from answering a question about whether or not I've given advice and what that may or may not have been about, I'm afraid.
Yeah, and that's not a line we can pursue.
Right, okay. Perhaps through another route, yeah?
Well, the law officers can't reveal their advice. That's the convention.
Right. Oh, and is it your understanding that the Prime Minister and the Cabinet knew exactly what was included in the...
I don't think the attorney can answer that question. It's asking you to go behind the advice.
Sorry.
Right, okay, thank you.
Okay. Any other questions on the COVID legislation?
No, not at this stage.
Okay.
I've got just a quick
one.
I just wonder whether or not you think that it was appropriate for the single justice procedure to be used. This is something we've had a bit of a concern about on the committee. Some of the fines that people were charged by way of penalty notices went up to £10,000, and it seems to there are some concerns. And certainly I have some concerns about using a single justice procedure, which is an administrative procedure, really, to deal with a fine of that size. The only way in which somebody who wishes to dispute it can do so is not pay the fine and see if they end up summoned to the magistrates' court. And if the single justice procedure is then used, they may not... We've all had trouble with post over Christmas. Yeah, they may not even actually receive the notification about the way in which it's going to be dealt with. Do you think that's appropriate for such a high level of fine?
Well, I think the single justice procedure was... there were specified proceedings which are subject to the SJP. It's a police-led prosecution, as you say, and applying only to summary-only, non-imprisonable offences where the defendant is 18 years or older when charged. It allows the suspect to plead guilty by post, and a single justice will determine the level of fine on the papers without a traditional court hearing. Now, the CPS only becomes involved in this SJP if and when a defendant pleads not guilty, at which point the case will be passed to the CPS to prosecute. I think that was a proportionate response, given the impact of COVID on resources, given and if we hadn't have done that, I think the backlog would have been even greater. It was, to my mind, a smart way, a proportionate way of dealing more swiftly with lower level offences.
£10,000 fine. £10,000 fine is quite a high penalty, is it not?
Well, I mean as I said, the impact. I think it was a proportionate response. We needed to find some mechanism whereby a swathe of these offences would be kept out of the CPS caseload. It would have been a very difficult scenario from a resources point of view. And on the whole, I think the quality of decision making. Yes, there have been some difficulties. There has been a review mechanism, and I think that strikes probably the right balance.
In some instances, of course, you had offences which created fixed penalties of £10,000, not even a fine. Now, were they implemented in any such? Is there any data as to how many such levels, how many fixed penalties at that level were actually imposed? I mean, maybe your department doesn't have that. But you see the issue about the fixed penalty at £10,000.
Yes.
You normally think of that in appropriate for a parking offence, something like that.
Yes. Well, as I said, errors were made. There's no denying that, and that's really why you're asking the question. when an error...
Proportionality point, isn't it, really?
Sorry?
It's a proportionality point.
It is, yes. And I think, again, it's always going to be a difficult line to draw. You know, where do you try and take a reasoned approach and carve out a cohort of offences from the prosecuting authority without jeopardising the quality of decision making? It's difficult.
Dr. Mullan, very quickly.
Just very quickly on this point, you know, you've heard the discussion here today, and you mentioned that there wasn't a template for this stuff. Would you agree that it would be sensible as part of further pre-pandemic planning that actually we should give consideration to how we might implement things like criminal sanctions?
From a criminal justice point of view, definitely. I think that there are obviously now, as we know, implications for enforcing and ensuring that enforcement is proper. And I think mechanisms to monitor that would be welcome.
That's very grateful, Attorney. There are a couple of issues we were going to raise, but the bell, I fear, has literally beaten us because we have a division, and I know there's multiple votes potentially, so I think we'll have to end it for today here. But perhaps we can write to you on the two topics around sentencing and open justice that we wish to raise. But I'm very grateful for your time and your evidence to us today. It's much appreciated. The session is concluded. Order.